Swayam Prabha. Digital India. Educated India.
Dear students, the last category which is mentioned in the TRIPS agreement of intellectual property is the undisclosed information or trade secrets. And trade secrets, what do you mean by trade secret? Whether all the secrets are trade secrets? It is not. There must be some prerequisites for some information to be considered as a trade secret. And we will look into what are the criteria for informations become trade secrets, and what are the measures to be taken to keep trade secrets, and why it is considered as an intellectual property, and what are the advantages and what are the disadvantages of trade secrets, and also some of the case studies like Coca-Cola, which we will see that one of the best kept trade secrets so far in the world. So, you can see the as I already told that one of the best kept secret the till date for centuries, it is kept as a secret. Why it is kept as a secret? Because it is a trade secret. The moment it is disclosed to the public or to anybody else, it is no more a trade secret. It must be kept a secret forever, then only it is going to be a trade secret. And why the trade secrets are important in the present day context? So, it is very important. The very few days back, the Economic Times reported that one of the Indian IT giant has been accused by one US company of trade the data theft, and they asked for a huge amount, the huge amount as compensation, and they are going for suits in the United States against the countries. This is not new. The Indian companies faces this kind of cases in the United States and other jurisdictions where trade law, the trade secret is considered as a very important intellectual property, and there is sufficient legislative measures taken by countries like United States for protecting trade secrets. And if you see some more examples, you can find in all these cases there are either there are the Indian people are involved, or the Chinese people are involved, or other people are involved in the theft of trade secrets from the companies, the American companies or other companies, they are involved, and there is heavy penalty or punishment is prescribed in the legislations of those countries. For example, the Uniform Trade Secrets Acts of the United States prescribes, and other state legislations prescribe heavy penalties for theft of trade secrets. So, you can be even jailed jailed for 20 years of time. So, it is more than life imprisonment in India. So, there is a heavy penalty in other countries. And I am not going to elaborate upon, just I want to tell that there is a lot of the cases have been filed in the United States and other countries where the trade secret is considered as an important intellectual property, and remedial measures have been taken by the authorities for the theft of trade secrets. And so there is a saying that the women are the best people to give away the secrets. So, we will see some of the cases later with regard to this. So, but if you look into the India, the trade secrets are not protected under any specific legislations. No specific legislation is available for the protection of trade secrets. Rather, India, there is the common law protection is following. So, there are contractual contractual law protections and other law protections are available in India for maintaining the data. So, the maintaining data is exclusively by contract between people So, whether it is an employer employee or it is a contractor and employee, this is exclusively based on the agreements, the confidentiality agreements or non-disclosure agreements between the parties. So, the remedies also will be depend upon what kind of agreements entering into between these parties. And you can see the purpose of these contractual agreements in terms of disclosure of confidential information is provided exclusively on the evidence of whether it is a theft or it is voluntary or involuntary of protecting trade secrets, whether there is any obligation on the part of the employees to protect the trade secrets. If you say that legislatively there is no obligation on the employee to protect the trade secrets of the employer, but the appointment orders or the non-disclosure agreements which compel or the common law which compel the employees to protect the trade secrets of the employees, which includes so all the people, those who, whether it is a business partners or it is business associates or it is research academics or the people those who deals with a number of secrets, trade secrets, and it is their duty to protect it as trade secrets. But the only problem is in the absence of an agreement, the taking remedial measures will be very difficult. So, if you look into the advantages and disadvantages of trade secrets, so you know that as I already stated that the Coca-Cola is one of the best kept trade secrets so far along with Pepsi-Cola. So, whenever there is an attempt in the Coca-Cola or attempt to sell some of the formulas to the Pepsi-Cola, either the Pepsi-Cola informed the Coca-Cola or Coca-Cola informed the Pepsi-Cola, and there is a cooperation between the two companies in protecting their trade secrets. So, as I told you, these companies never applied for a patent. So, it is never required to disclose the formula to the public. One, at the same time, the trade secret never you have to go for a patenting process at all, but the problem is that it is never available to the public at large. So, any trade secret will be considered as secret forever unless until it is disclosed. So, and also there is no legal scrutiny or legal security against independent competitors. That means, once the moment if the trade secrets are leaked, trade secrets are disclosed to somebody, it is no more a trade secret. That means, there is no monopoly protection available to them for a limited period of time. That means, the protection is forever unless until it is kept as a trade secret. So, a trade secret is not the protection or the invention of the 21st century or 20th century. So, it is mentioned that the famous the painter Leonardo da Vinci, and when he makes his paintings and he kept it, he never allowed anybody to enter into the hall when he is painting. He kept it as a secret, how the method of painting. It is said that it is kept it as a secret. It means the application of trade secrets are from the very beginning, or it is a time immemorial period, and the secrets are kept, but trade secrets are kept is for only for some of the products, mainly because of its uncertainty of its security. Uncertainty of security, once it is released, it is no more a trade secret. So, if you, because there is a lot of why it is a neglected sibling, trade secret is considered to be a neglected sibling in some of the countries like the developing countries, but in the developed countries this is considered to be this one of the best legislations to protect the trade secrets, because the value of trade secrets are very important to the companies, like whether it is Coca-Cola or it is Pepsi-Cola. The moment it is the trade secrets are released, or whenever there is an attempt to release these products, or if you look into the history of this production of these particular products, it is always kept it as a secret. And also the cooperation between competitors is also very important, keeping the secrets, and the best examples are the as I already mentioned, that the cooperation between Coca-Cola and Pepsi-Cola is also is best example of how they prevented others from the theft of trade secrets of companies each other. And here you can see that the protection of every data is not trade secret. Then what is trade secret? The trade secret, definitely the name itself saying that some secret which has to be kept as confidential, that are the trade secrets. And for example, it may be an idea, it may be a database, it may be any kind of information which can become trade secret. It may be a clinical formula, or it can be a database of clients, it can be the financial strategies of a company, anything can become trade secrets. But a mere data is not going to be a trade secret, but it must be depend upon what that data have the value to that particular company. So, when the trade secrets are preferred, because if you look into the Coca-Cola would have been gone to the market with a patenting, then it is only valid for a limited period of time, and they lost the entire value of the company after the period of time. But now it is kept it as a secret forever, and so the value of the company has increased, and they always keep it as a secret. So, it is unlimited period of time the trade secrets can be kept. So, though there is no limited period at all. And but even the cost of the patent protection, the cost of patent protection are says that it is prohibitive. From time to time you have to go for renewal of the patent protection, and it is only for a very limited period, but the trade secret protection is for, it can be for centuries, it can be for years. And when also you can go for trade secret protection when a product is very difficult to reverse engineer. If it is very easy to reverse engineer, then it is better to go for patent protection rather than trade secret protection, because once it is reverse engineered a particular product, it is no more going to be a trade secret. And what are the measures to be taken for this guard the trade secrets? So, for example, in the case of every company, you restrict people from access to this kind of information to the employees. There will be always some employees have access to this particular information, but that is not going to be the trade secrets, but all the employees should not have access to this kind of informations. And also signing confidentiality agreements with business partners, with employees will always help to keep the trade secrets. And also you can see that the protective techniques, the new techniques like the digital data security tools, which can be used for protecting this particular data and different people accessing the data. So, restrictive measures can be in the form of passwords to the systems which are accessible to the employees. And most of the countries, many countries have national legislations in protecting trade secrets, but unfortunately India does not have a trade secret protection law as such. And as I mentioned about this particular the Aranmula mirror in the geographic indications class, that this is registered geographic indication from Kerala, as well as the mixing of these particular metals are only known to few people. It is for centuries it is considered as that is the alloy. What kind of metal alloy is used for making this particular mirror is considered as kept it as a trade secret. So, the moment it is become a trade secret, it is no more going to be a trade secret, but always it is going to be considered as remains to be a GI, geographical indication. So, there is a double protection as a trade secret as well as a geographical indication of the same product. So, you can limit the access of information to the secrets of whether it is can be a formula, it can be that particular information to make that particular product, it can be keep it as a trade secret. So, at the same time, but if you are not taking sufficient means to protect that particular information as a trade secrets, then it is no more going to be become. So, it will everything will depend upon to what extent you take precautionary measures to limit the access to that information will decide whether it is going to be a trade secret or not. And secondly, you must have been taken sufficient means to keep it as a secret in the ordinary course of trade. And thirdly, it should be kept it away from the people, those who have access, ordinary access to that particular information. Then otherwise also it is not going to be keep it as a trade secret. But in India, you can find a number of cases where the courts, Indian courts are always in favor of protecting the trade secrets. You can find a number of cases where the Delhi High Court and other high courts are held that it is the duty of employees to protect the trade secrets of the employer, and whenever there is a theft, the court has taken the common law remedies of whether it is injunction or damages under the common law remedies available to the parties in India. So, as far as the trade secret is concerned, it is one of the important category of intellectual property law, and in developed countries there is specific legislations to protect trade secrets, but developing countries like India has so far not come out with the specific legislations, but still it is protected through the common law remedies which is available to parties like non-disclosure agreement and other kind of agreements between mutual agreements between the parties. Even in the absence of any kind of agreement between the parties, the courts have held that it is the duty of employees to protect the trade secrets, and whenever there is a theft of trade secrets, the court has taken note of it and provided the remedies which is available in common law. So, I think we have covered all the 7 categories of intellectual properties covered under the TRIPS agreement, starting from patent. Then we have covered the trademarks, then we have covered geographic indications, and we have covered copyrights, and then we have covered designs, industry designs, then integrated layout designs, and also we have covered the trade secrets law, the 7 categories. So, this class is mainly the objective of this class is to know, before we going to intellectual property and competition law, the interface between intellectual property and competition law, you must know what are the categories, the basics of intellectual property law. My objective is not to give a elaborate discussion on the provisions of intellectual property protection, but the limited objective of this week class is to give an idea about what are the different categories of intellectual property law. The next week we will go to the basics of competition law, and before that you must understand the basic categories of intellectual property law. I hope that this will help you to understand the interface between intellectual property law and competition law. And so in 2015 I have already published a book on the competition law and intellectual property law, which is mentioning about the interface between these two. So, the next week we will deal with the different the basics of competition law. Thank you.